Okay. So, I saw this come across in a memes channel of all places, and this is actually pretty funny and in a lot of ways monumental because Nintendo has been going after Palworld or Pocket Pair for lawsuits and throwing their weight at smaller companies in order to shut down projects that compete with Pokemon. But what this is removing some of the supposed grounds that Nintendo has against Pocket Pair to basically GIMP Palworld. This is within a string of things that of wins versus against Nintendo that Palworld has gotten over the time, but this is probably the biggest one because this is the Japanese patent office rejecting one of the relevant applications to it. And this particular one is really funny because it's, in a lot of ways, it's core to Pokemon, modern Pokemon games, depending on how you look at it. And in many cases, this core mechanic wasn't even fleshed out until later on. But anyway, so the context here is Nintendo's patent infringement litigation. Everyone knows about it, I think. Pocket Pair is basically running on invalidity arguments, which is basically... Oh, wait. This is for one of them where Nintendo's like, hey, this, that, and the other. Mods for Palworld don't count as prior art or whatever, so when someone mods the game, technically, whatever, it's the mod maker, not Pocket Pair that's at fault. Maybe part of a PR strategy to distort the reality of who was first to create what, given that Nintendo itself is apparently developing a Pokemon spin-off with the Palworld-like elements. This actually sounds like it might be pretty accurate because Nintendo has a habit of going after projects when they are getting close to announcing a project that is spun like it. So the fact that Nintendo is going after someone smaller with this one is like, when are they announcing the next thing? And we didn't see that with ZA Legends, I think. But yeah. Let's see. A decision called office action made by patent examiner of the Japan Patent Office less than 2 weeks ago cast serious doubt in the validity of two of Nintendo's 3 Japanese patents in suit. This is about pending application number, that one, that is a sibling of one of those anti-Palworld monster capture patents, and the parent of another. It has been rejected on a non-final basis because the Patent Office, after a third-party submission of prior art, determined that the claimed technique lacked an inventive step. The prior art references cited by the JPO include various games that predate Nintendo's December 2021 priority date, among them Studio Wildcard's Ark, Capcom's Monster Hunter 4, Pocket Pair's Craftopia, and Japanese browser game named Kantai Collection, and Pokemon Go. So Pokemon Go would be under the IP technically, but Niantic did the throw a ball and capture things mechanic before any other Pokemon game did in the fashion that they did. So you had Pokemon Go come out, Pokemon Let's Go came out, which was kind of under the Nintendo wing, but still Pokemon Go is technically contracted by Nintendo to be developed by a third-party company. But it's still prior art that they didn't file this patent for before. Nintendo now faces the choice between abandoning the embattled patent application or, which is the more likely step, trying to persuade the patent examiner based on the modified patent application with amended claims. Also, when the process of the patent office is over, an appeal to specialized court named intellectual is possible. The Japanese patent prosecution process has been described as an endless loop. But the fact that the patent examiner is now looking at real-world games as opposed to just patent documents and articles considerably ups the ante for Nintendo. So this means Nintendo is going against prior larger studio game mechanics in trying to patent a mechanic that has been in their games before. So the whole mount mechanic thing done in World of Warcraft, if they look at that, it's like, well, this one is like flat out like not even valid. For the avoidance of doubt, even if this Nintendo application fails, there's no direct impact on the Powerworld patent case. However, see the next section. So let's actually open amended claims and go invalidity arguments, prior art. Let's double check and make sure that... Okay, so amended patent claim and one that has been modified in order to address concerns over whether a patent application be granted or whether an already issued patent can... Oh, these are invalidity contention. Why patent claim should be declared invalid and revoked. Most common invalidity contentions involve one or more prior art references, arguing that a prior art reference anticipated the relevant patent application, or that two or more pars combined, or one or more if combined with common general knowledge, rendered non-inventive, rendered it obvious. So I think we've seen enough games. Generally with common general knowledge, you have at least 5 different references from 5 different places, and that counts as common general knowledge, and therefore, like, you can't patent it. And I think we've seen the monster capture mechanic is rendered in, like, most Pokemon games now, modern Pokemon games, being in such a... in that case. So, like, you've got Temtem that I think follows a similar idea, and so on and so forth. A bunch of others that follow along with this. And so those prior arts basically make it invalid in common general knowledge. Therefore, yeah. And then you look at the mount thing, and that I'm pretty sure would fall under general common knowledge, just due to the way that that works. Let's see. Okay, that one, let's see. Based on analysis from the leaked video and related expos, the game in development incorporates Palworld-esque mechanics. Again, Nintendo's stealing mechanics from other things, which is, at this point, what they've decided to do. So, like, expansive seamless open world, capture creature in combat, survival elements. Like, this whole survival elements thing is common knowledge at this point across the board. Multiplayer and co-op game, tone and progression. I think darker mature themes, like blah blah blah, whatever. Trying to shut down another project. Make your project good instead of shut down other projects that compete with it, honestly. But anyway, wider ramification. The non-finally rejected patent application is the key building block of Nintendo's monster capture patenting strategy that took aim at Palworld after its early 2024 release. Has the same parent application as that one and is the parent of blah blah blah, both of which is Nintendo's asserting against Palworld. Just like the game application that led to the patents in suit, this application was filed shortly after Palworld's release. So, yeah. Let's see. Go back to their prior article. So yeah, these two relate in... I've done a video on this previously. I can try and link it. It's in there somewhere. An issue facing a central member of a patent family is often indicative of validity problems facing other members. Overlap between invalidity contentions underlying the rejection and Pocket Pair's defenses makes it plausible that Pocket Pair could be behind an April 2025 submission to the JPO in connection with its Nintendo patent application. Let's see. Yeah. JPO decision, much less a non-final one, is not binding, and presiding judge Motoyuki Nakashima, who is handling the Nintendo v Pocket Pair case, but judges are legally trained and intend to have respect for the determination made by patent examiners who are technically trained. Pocket Pair might try to point the Tokyo District Court to relevant developments in the JPO. In the US, that would be called a request for judicial notice and can influence decisions. We assume that there will not be a decision of any kind of the infringement case before next year. The proceedings have been delayed, presumably due to what the next bullet point mentions. Nintendo's third patent in suit is also in trouble. They felt forced to seek a modification in the middle of litigation. So if we pop this open, weird patent claims. So last fall, Nintendo and Pokemon Company sued Palworld, blah, blah, blah. Explain it to me like earlier this year, we launched an Explain It to Me Like I'm 5 series covering the dispute. Sent a Japanese attorney to a Tokyo courthouse to take a look at Pocket Pair's defenses and reported on them 3 months ago. Subsequently, we explained Pocket Pair's moving target strategy that involves changes to gameplay mechanics so as to work around Nintendo's patents, making it impossible so far for Nintendo to find a basis for a good faith US patent assertion. Nintendo would apparently like to sue in the US as well, but so far it can't. Clear sign that Pocket Pair's defenses have also made a strong impression on Nintendo. The latter ran to the JPO in the spring and requested modification of one of its 3 patents. Furthermore, we'll take a look at Nintendo's latest tactic. Modified patent claims on the smooth switching of writing objects, even when is awkward patent claim language. For recap, Nintendo is asserting that 3 Japanese, 2 of them relate to the collection of characters. And the third is about the smooth switching of riding objects, such as switching from horseback riding to flying on the back of a bird-like character. We're now talking about the third, not the other 2. We reported earlier this year the Japanese patent attorney does not believe that Pocket Pair ever implemented that switching mechanism. Also, the gliding functionality that Palworld had when it launched, and which was recently removed because Pocket Pair wants Nintendo's patent assertions to go nowhere, was already demoed by Pocket Pair in June 2021. 6 months prior to the original Nintendo patent application, based on which Nintendo then filed for new patents well after Palworld's launch. As we explained in the article we just linked to, what matters legally is not the filing date of a patent application, but its priority date. You can claim back priority to an older application if you file a new one that is derived from the same substance. However, Pocket Pair has presented plenty of prior art. It predates not just the patent application, but also their relevant priority dates. So that's important. Nintendo has filed patents after the priority dates of prior arts that have already implemented certain mechanics. Concept of being able to derive something from an older, in this case almost 4-year-old patent application while benefiting from the older priority date is very relevant now that we're talking about Nintendo having modified its smooth switching patent. The same principle applies to any modifications now. Nintendo can use the original patent application as a pool, like a primordial soup. That's fair game, but it's limited to that because it would otherwise not be entitled to that original priority date. So here's a PDF in which we saved an English machine translation provided by the JPO itself. Decision that finds that those claims do not introduce any new technical matter, meaning that, to use our metaphor from further above, the modified claims are still based on what is found in the 2021 primordial patent soup. So, yeah. So basically they tried to modify certain, small wordings, and they were denied that because it basically doesn't mean anything. We looked at the new claims. We were neither convinced that Palworld, at least in its current form, infringes them, nor that they are capable of overcoming Pocket Pair's strong invalidity defenses. But what really stood out is the way that the claims are worded. Here's just one passage. Even when, emphasis added, any boarding character other than the aerial boarding character capable of moving in the air is the currently selected boarding character, and a first operation input is given when the player character is in the air, the computer causes the aerial boarding character to appear in the virtual space and causes a player character to board the aerial boarding character instead of currently selecting boarding character from among the boarding characters. Now, the patent claims are not like everyday language, but the above type of wording is extremely contorted, trying to complicate things for the purpose of putting up a huge smokescreen, and above all, even when is normally not found in patent claims. Even when has never been there before, or even if in a patent claim, just bizarre. Conditions if and when are normal in patent claims, but even is a word that has no place in a patent claim. Even is basically just adding more emphasis onto something, and it means nothing in this case. It's too emphatic and subjective. Patent claims have the purpose of describing how certain means are used to achieve a particular end, and to do so in a way that at least those who know a thing or two about patent law will have an idea of what the patent covers. The name of the game is the claim. Let's see, new U.S. claims may still not enable Nintendo to bring a reasonably strong U.S. patent lawsuit against Pocket Pair. Yeah. So basically, Nintendo's trying to modify old patents that they can't go after, but Pocket Pair and those allied with Pocket Pair are pulling prior arts from even before Nintendo's earliest patents on this, which is actually what is most necessary, is providing like proof that like, hey, Nintendo has no grounds to do this, because look at all these other prior arts that basically make this patent general common knowledge. And which means Palworld in all its stripes, Palworld in all its stripes basically can get off with the way it stands. And I think the gliding mechanic in many ways might be something you could look at and find where Nintendo copied it from somewhere else, quite possibly. If you liked the content, if you enjoyed it, if you think I deserve it, like, comment, subscribe, leave any criticisms you have or what have you. I appreciate it. Feed that algorithm, like I said, and I will see you guys in the next one.